Yeah.
Okay, so we are live with Gennaro Gerald Gatto, and we're going to talk about all things real estate law, including fraud. There's been some fraud talk. So what's going on with the wire fraud specifically?
Well, a lot of emails are being hacked, and I think it's called phishing or something. I don't know if somebody gave me the term. There's a term.
It's phishing spelled with a PH.
Yeah, PH, right? And so what's happening is, and it happened to me about 3 weeks ago, where I had a client's void check to direct deposit the money into his bank account. We try to do that as a convenience to clients, rather than them coming to our office to pick up checks. And I had his void check. Half hour before I was going to deposit the check, I got an email from his email to me asking me not to deposit the money into his Scotia account. They knew it was a Scotia account. They said, please don't put it into the Scotia account. Can you put it into our TD account? Here's our banking information. Here's the name and everything, right? The only thing that tweaked me, it wasn't his name that they wanted me to deposit. It said, put in my company's name. So, as a lawyer, if I owe money to Nick Carazza, he can't say, well, pay it to Rockstar. I can, but I need Nick to sign a direction authorizing me to make it payable to Rockstar. So I happened to call the client. And I said, Dave, why do you want me to put into this account? He had no knowledge or information about this email coming to me asking me to do it. So somebody's trying to get us to put $100,000 into the wrong bank account. And I was at a seminar in Wednesday, Thursday. They run a 2-day seminar. It's called the Law Summit for Real Estate. And this topic came up, and they're now suggesting when you're about to deposit money into somebody's bank account, pick up the phone, call the person, and don't call the number that's on the email that they're sending you, because sometimes that's even fraudulent. So if I have Nick's number and the email says to call, 416-9233, and I know that's not Nick's number, pick up the phone, call the person directly, and just confirm that the banking information that you have via email or by fax is correct. There's so much going on. There was an incident just recently where a client got an email from his lawyer asking him to put, I think it was $170,000, $180,000, said you need to put it into my trust account today because the bank wants to see that I've got the down payment in my account. The client put the money into the bank account, turned out to be a fraudulent account. Client's now at $180,000.
Yeah, and there's no, like when you put something on your Visa or something, there's some protection there. But with that type of instance, when you're taking the money and putting it in that account, there's no backup. There's no insurance to it. Yeah,
you're out of luck.
So how are they finding out, like in your first instance with the closing?
Well, they're hacking into your emails, and they're following the conversations.
So they know you have an upcoming property.
That's right. Yeah. So I just had one recently with the Minister of Finance. And they had to send us back a refund check for like $10,000. And the girl from the Minister of Finance called me and sent me an email and said, hey, how do you want me to send you the check? And I said, well, mail it to this address. And I gave her her address. Week, 2 weeks, 3 weeks, I didn't get the check. So I called her. And she goes, oh, well, I put it into a bank account for you. I go, what do you mean? She said, well, shortly after you told me to mail it, you sent me another email saying, don't send it, don't mail it. Here's my banking information. Put it into my bank account. So she went. Now, I said to her, but the account isn't Gerry Gatto Professional Corporation. It was some numbered company. I said, why would you do that? She goes, well, that's what your email said. So now I'm fighting with the ministry. They're going, well, it's my problem. I go, it's not my problem. You guys put it into the wrong bank account. But very, very important that clients being asked to put money into people's accounts, right? Really important that they contact the person whose account they're putting into just to confirm that the details they have in hand are accurate. So we're saying to all our clients, before you go to the bank, because we do lots of times, we'll have clients deposit money into our bank account or wire money to us. So we're saying, before you do anything, pick up the phone, speak to somebody from my office, and just confirm that the banking information you have is accurate.
This applies to everyone, like anyone dealing with funds. So investors, tenants, we're going to send something out to our whole team. I went and talked to Serena right away. I'm like, if anyone reaches out to you to change direct deposit instructions, don't do anything. Call the company, call the information that we have on file. And then, because we're doing EFTs regularly, right? Because we're paying out different brokerages. And I'm like, well, how easy it would be for someone to figure out, hey, why don't I just get a brokerage email address from Remax, WorldPay, whatever, some brokerage, and go to some of the brokerages and say, hey, can you please update our direct deposit information? Because they know they're always paying out commissions. And I'm like, oh, we got to watch this, because this is going to be everywhere. Is
this relatively new, this wire fraud, like this new angle?
I don't think it's relatively new. I think what's happened is that it's just got a little bit more sophisticated. I think that's what it is. I think they're picking and choosing where the funds are now. Like they've realized that they have more access to information, and I think they go to where the funds are. Because what I learned is that on the, if you heard of the dark web, right? You can go online and do all sorts of crazy stuff. So my understanding is that there's basically, when there's these leaks, these hacker leaks that they go to third-party companies where you might have shopped online or something, and they get some of your information, but they associate it all. So there's these profiles, and then there's people that will compile these on the dark web, or they sell it back and forth, information or something. I don't know exactly, right? But there's profiles. So like Anthony Molinaro, there's a profile, and there's going to be his email address, and there's all the information that they know through multiple leaks have been consolidated, and you have this profile on the dark web. So they know certain things about you that they can, if they choose you as a target, they might be able to figure something out, and they might be able to get something from you.
Wow.
So that's when you asked about how did they finding out, I started thinking right away, because I'm like, oh, are they seeing who is buying the property and then trying to link it up with, like, do we have access to their email? But usually the buyer's not public until it gets registered. So I don't know how they get, and then the lawyer, how do they find the lawyer?
My understanding is they're jumping, like, for example, they're watching my emails.
So you think that your email got compromised?
My IT guys have now done for me is they've done authentication.
Two-factor authentication.
Two-factor authentication, where somebody other than I go on to my email, it sends me some kind of notification. But you know what? They broke into the Pentagon. I guaranteed my two-note authentication is not going to stop them. But and it's not just, like I said, I was at a seminar, and they spent at least 45 minutes just talking about the fraud, and they're targeting lawyers because lots of money goes back and forth, right? Banks are sending money, we're sending money to other lawyers, right? So a lawyer will say, here's my wire information. Okay, great, we'll send you the $600,000 to that wire information. So what they suggested was, before you send anything, pick up the phone, call that law firm, call that brokerage, go, hey, we've got CIBC, this is the information we have, here's your account number, is that accurate? Because it's one thing if I go to your bank to direct deposit the money. It's a little safer. So I go to the bank and here's Nick Karatz's money, and the girl can say, well, it's not his account. Okay, great. I can stop it. But wire, once you go to your bank and you wire it out, it's gone. You have no more control over it. So really, really, everyone has to be super, super careful to double check where money's going out. Because to Nick's point, if it's gone, it's not like a credit card where somebody grabs $5,000 or $6,000 in your credit card. Your credit card will cover you. You're out that money.
We got a call once at the brokerage. It was one of our listings that someone took, and then they put it privately online, and then they said it was theirs, and they ended up wiring someone money for the property. And I was like, I'm sorry, they were up in arms about it. I'm like, I'm sorry, like, this has nothing to do with it. It wasn't us. Yeah. It has nothing to do with us. I'm sorry. And I felt bad for the people. It was a rental, right? And they were trying to get into the rental, and that's how they did it. And I felt bad. But
so it was like 1 month's rent?
Yeah, I didn't know what they ended up sending them, but yeah, probably one or 2 months rent, depending on what those people convinced them to send, right? And I was just like, yeah, I don't know, man. People that take advantage of people like that and with these types of scams, it's just low people to me. It doesn't sit well.
The other thing that, and this is more for real estate offices, they've had a couple of instances where someone will give you a big deposit check, right? For $100,000, $200,000, $300,000 on a big transaction, and then call you and say, "Oh no, the condition didn't get waived. Give me back my money," right? And it hasn't cleared your account yet, and you're sending out the money. There was a lawyer in Toronto that the money got paid to him, a $500,000 deposit. Client called him and said, "No, deal died. So send me back my money." He sent the $500,000. Well, guess what? Client's $500,000 had never cleared and never did clear. It was all a scam. And that's how they launder money as well. So they'll dump money into your bank account, either lawyer or brokerage, right? And when you send it back to them, you're actually cleaning the money for them.
Oh, wow.
Yeah, brokerages used to be a big target for laundering before FinTrack.
Yeah.
For exactly that.
Just because so many big lump sum deposits are coming in and out of the trust account?
Well, it's easier. Like, it's easier to do a 50,000. You can clean 50,000 at a time. How many places can you go and clean the 50,000 at a time?
Like, make a transaction that big?
Yeah, you can buy a larger house. You can put $100,000 down payment on a big house and be like, you know what? Sorry, financing didn't come through. Give me $100,000 back. So.
And all of a sudden you take the money from Rockstar and go put it in your bank account. Anybody questions it, well, it came from Rockstar. Yeah. Nobody's asking
it's that easy to clean? Like, you could just take it from bank account A?
No ideas, Anthony. Don't get any ideas. But
it's that easy?
I mean, I guess, there's more things in place now. There's more checks in place and more questions. We have to ask our brokerage, and we have to take more ID, and we need, if it's through a corporation, we need paperwork from the corporation. So it's the FinTrack laws, the anti-money laundering laws from the government. The brokerages, you guys do all the same thing. The lawyers do the same thing. So there's more. We have to be asking more questions than we used to have to ask. This was a number of years ago now, but it still happens for sure. But I think the point you made about money orders or bank drafts is a big one, because a lot of people think those things clear faster. And what I've found out is sometimes they clear even slower. So if you're getting a money order from someone, a bank draft, so again, from tenants or anything else, that thing might take if it's fraudulent and done well, it could take a full couple weeks before they find it, even if it's from one of the big banks here or something. So it's not like it's any slower. You need to let that stuff sit.
It has to. You have to be sure. And to be honest with you, I didn't realize up until a little while ago, even a certified check, you can stop payment on a certified check. Mm-hmm. To me, I was always of the opinion that a certified check is cash.
Yeah, I didn't know that either.
You can stop payment on a certified check. That's what I've been told. So, so somebody gives you a certified check, that's not the end all and be all, right? So if it's a source that you're not sure of, and that's how they do it. They give you something that's certified, which is actually no good. You go, I got a certified check. I'm good to give the money back. And then that certified check bounces on you.
So what's the optimal way that you're collecting money now?
Well, with our clients, we're getting certified checks from clients, right? But a client that's buying a house, we're putting the house in their name. There's less chance of, you've got a closing. The house is going into Anthony Bolinaro's name, right? And they're giving you their deposit. And I know they've dealt with Rockstar, the Rockstar clients, or whoever they work with. There's a little bit more comfort, but the ones you have to worry about is the ones that come in and go out really quick, right? And all of a sudden the deal fell through, right? I had one of the lawyers in my office, actually, not in my office, but one of my associates, I had this guy call him and say, I'm going to purchase a property. He goes, it's going to be a $4 million purchase. He said, I'm going to send you the $500,000 deposit now. That way you've got it in your account when we make the deal. He came to me and I said, why is he doing that? And why would a guy give you a $500,000 deposit to hold? Oh, it just makes it easier. No. And it turns out that, he didn't end up taking the check. He went somewhere else, had it happen, and the guy was out $500,000.
Oh my God.
So there's, stuff, the point is, you know what? You have to dot your I's and cross your T's. You have to be super, super diligent. When you're sending money, you have to make sure you know exactly where it's going.
Now, these numbered corporations, is there a way of verifying who the shareholders of that corporation are? Like, can't that be traced?
I think you can verify the directors. I think you can verify the directors, not the shareholders. I don't think that the shareholder, because the shareholders sit in a corporate, you don't have to register who the shareholders are. You have to register the officers and the directors.
So couldn't that still be traced back if someone was like hiding behind?
Well, I have to tell you, I was a little disappointed in our banking institution because
Gerry, don't talk bad about the banks.
No. But I had this email that came to me that gave me this banking information from TD Canada Trust, and obviously my client said, no, it's not me. So I thought, oh, great, we got him. We got him. We're going to, right? I go to Canada Trust and I go to the guy. They're trying to scam me $100,000. You should look into this account because obviously, you know, it's a TD account. Somebody had to open it up. Guy goes, yeah, we'll look at it for you. I never heard anything else. And that's what they do. They'll open up an account. So they'll open up an account for 2 days, put the money, get it out, close the account. So that's the other thing they're saying. When you go to your bank to put money in, say, how long has this account been opened up? If the guy says it's only been open for 2 days, something wrong. You have to really, really be careful because they close. So, you know, when I went to TD, I thought the guy was going to say, great, you know, we're going to call the police right away. He goes, yeah, we'll look into it. We'll get back to you. I never heard a word from anybody.
Oh, wow.
What else you seeing on the streets? I mean, with the rates going up over last year in the fall, people were screaming like, "This is it." There's power sales, and we saw the numbers. We shared the numbers before during the local market update before, just how power sales were trending upwards, and they're higher.
But not crazy. Not crazy.
So you're not seeing anything come across. I mean, there's probably one or two, but nothing crazy across your desk.
Nothing crazy. I mean, I've had a couple purchases on power sales recently, but nothing. I mean, I'm not seeing 10 or 15 of them. I'm seeing the odd one here and there. Nothing crazy. ID's still a big, a big problem on mortgages. I'm shocked at how, typically when we close a transaction, we ask clients to make sure Canadian passport and driver's license, those are the best two pieces of it. You'd be shocked at how many people don't have that. So, you come...
But they don't have their you mean they didn't bring it to your office?
Or a driver's license, or it's expired, the passport's expired, hasn't been renewed, the driver's license hasn't been renewed, right? So, and you send it to the bank, and the bank rejects it. Bank won't take that ID, especially if they're elderly people. We're finding that. So I'm saying to everybody, guys, you got to, when you're dealing with somebody, ask to see their ID. Make sure it's valid. Make sure it hasn't expired. And if they don't, they got an expired driver's license, you got to say, get your butt into Service Ontario and get this renewed, right? Your passport, get it renewed. Now, can't do it now because we're on strike, but that's okay. But, really important because a bank, with the amount of fraud that's going on, you've got title insurance that has to be satisfied because they're insuring against the fraud for the institution. So they're being diligent in their review of all the ID, and the banks are being diligent in the review. So, I always, real estate agents, guys, make sure that you see the client's ID. You guys have an obligation to look at their ID, correct? I think you only have to see one piece, though.
We do. Yes.
Yeah. So with us, we need two pieces. And, if you don't have the two pieces, you're not getting a mortgage.
Would they accept those temporary ones you kind of get in the meantime before?
Yeah, we do. That's what we do. But you have to, that's what I'm saying. You have to get there. You may not have your valid card, but as long as you get your card, it's expired, and they give you the, like a sheet there that's saying it's been renewed and stuff. That's good enough. But Canadian passports, especially now with, the restrictions on foreign investor purchases and things like that, right? They really put an onus on the agents. They put an onus on the realtors, on the lawyers to make sure that people are Canadian citizens, so that, because if we make a mistake, we can get fined.
Yeah. Isn't it great that they make these rules and they say, okay, here's a new rule. It's up to you guys to figure it out.
Yeah.
Go figure it out. And by the way, if you don't figure it out, we're going to fine you.
Yeah. It's a $10,000 fine.
Yeah.
Figure it out. So
it's a good system.
So I'm always saying to clients, you're going to buy a house, make sure you got your ID in place. and if you don't have a driver's license and you don't have a passport, you can go to Service Ontario and they do have ID cards. They're government issued ID cards. Looks very similar to a driver's license, except it's an ID card. All it is it's got your picture on it. It's issued by the government of Ontario, and that's acceptable.
And you would get that if you don't have a passport or a driver's license?
Yes.
Is that like a PR card, or it's entirely different?
No, it's just it's an they call it identification. I think it's $40 to get or something. It's nothing ridiculous. And it looks, if you look at, I think it's pink instead of blue. The driver's licenses are blue. These things are pink in color, I believe.
The provincial ones.
Yeah, the provincial ones. Yeah.
Okay, I think I saw those once from a tenant applying for a property or something.
Yeah. It's it's just strictly ID, because you can't, if you don't have a government issued photo ID, you're not buying a property in Ontario.
Yeah, and your health card you can't use.
No, can't use health card.
Yeah, that is weird. Why can't you use that?
No idea. They never let you use it.
Yeah,
I remember from my security days when I was working at clubs, they're like, you can't bring in the health card.
Yeah.
Everything. You can't use it.
Well, I think the reason, and it's funny because other provinces let you use it. Ontario's one of the only provinces that doesn't let you use it. I think the reason is because in Ontario, you can get health care just with the number on the card. You don't actually need the card. So if I got access to your number, I can get health care using your number. And that's why they don't want the cards, because they don't want the numbers being banked.
That seems like an easy way to skirt the healthcare system.
Yeah, I don't know. But I mean, that's the problem. Lots of clients, here's my health card. Sorry, I can't take the health card.
Yeah.
Can't take the health card.
Yeah, just come up a bit, Gerry. Have you dealt with any cases of mortgage fraud?
No, I just got off the phone with somebody.
Not yet, but in about 24 hours.
Yeah, I just got off the phone with one of my lenders who was about to do a second mortgage on a property, and he reached out to the first lender, and the first lender said, you need to get a hold of the police because we think this is fraud. I just got off the phone before we started, so that's the first time I've ever run into that.
Wow.
Yeah, and we do a lot of private mortgages, so we're very careful when it comes to the ID that we get from the other lawyer, because obviously when it's a private mortgage, there's another lawyer involved. So there's somebody acts for the borrower and somebody acts for the lender. We typically act for the lenders, and we're very diligent with what ID we get from the other lawyer, and
What's the most common case of mortgage fraud? Is it people just like boosting their numbers?
Stealing your ID and putting a mortgage on. I mean, if I get my hands on your ID, I can get my picture put, I've been told, I don't know this firsthand, I've been told I can get my picture put onto your passport for $200 in Toronto. I can then go to a bank and say, hey, I'm Anthony Molnaro, I own this property.
Or the Italian Social Club in Hamilton.
Yeah.
In the back.
Yeah.
And that's the problem. There was a case just recently in the news where a young couple went on a 2-week vacation. They came back and somebody was living in their house.
Yeah, their house got sold.
Yeah, their house got sold from under them.
What even happens in that?
Well, now that's
how do you unpack that?
We talked about title insurance. That's where title insurance comes in, and that's why it's highly recommended that. Well, if you're getting a mortgage, you have no choice with title insurance. You have to get title insurance because the lender wants title insurance. But if you're paying cash for a house, I still highly recommend you get title insurance. And I know lots of people, I don't need it. You know what? If you become a victim of it, you'll end up getting your house back, your property back. You'll end up getting, but you're hiring a lawyer, you're going to court. I mean, you're paying for all of those things out of your own pocket. Where if you get title insurance, they take care of it all. They hire the lawyers. They do. It's like car insurance.
With the amount of fraud, like maybe, a while ago, or maybe it just wasn't prevalent, or you didn't hear about it as much. Just there wasn't as much information sharing, online and stuff. But with the amount of fraud that is going on now, or that at least it feels like there's substantially more. It seems like a no-brainer.
Absolutely. And it's a one-time fee. The title insurance is it's not like you have to, house insurance, every year you get your bill, you got to pay it. Title insurance, it's a one-time fee. If you own a house for 20 years and you become a victim in your 19th year of ownership, your title insurance still covers you.
What was coming to mind, I was just thinking about you closing deals, and one thing that you've always been good at, or I've always liked about the way you handle it when you close deals in your office. Sometimes Gerry will just pick up the phone and be like, "Hey, let me get the other lawyer on the line." You'll pick up the phone, you'll try to talk to the guy or girl, and just get it all sorted out, and then move on. Versus the other approach that I've seen is that it's like, okay, well, we'll send a letter, and the letter gets, dictated and sent over to the lawyer, and then another letter gets sent back. I'm like, what the hell? This is the slowest process, I've seen in a long, long time. What percentage of the lawyers you deal with when you're closing deals, I guess maybe when there has been issues that have come up and you've had to kind of get them on the phone, what percentage of them are willing to just kind of pick up the phone and have that discussion and get things resolved very quickly versus the ones that are still kind of shy away from that and wanted a very formal back and forth, faxed or emailed dictated letter, to resolve things? Because it just seems like so antiquated to me.
Well, and the reality of it is that I find that the older lawyers in the bar that have been doing this for 20 plus years have no problem picking up the phone and talking, right?
No, you'd think it's the opposite, right?
Yeah, and I find the young guys email,
text message? No,
message.
Don't tell me you guys are trying to get deals closed over text message.
I've got lawyers, put it to me in writing. Just let's talk about it and let's resolve it, right?
Yeah.
I mean, to me, my philosophy has always been as a real estate lawyer is my function is to get the transaction closed, not to kibosh the transaction. I've got a purchaser that wants to buy. You've got a seller that wants to sell. Let's make it work. And not everybody that does real estate has that philosophy. Some guys, unfortunately, want to make it look like they're superstars and, they can nick it. There is problems, and sometimes the deal can't close because of a problem that cannot be resolved. But I've always had the theory that if the two lawyers get together, between the two of us, we can figure out a way to make the thing work. If you've got two willing parties, why would I try and kibosh the transaction?
So what's an example of what a lawyer would do to kibosh it if they're trying to be like a superstar?
Well, I had one just recently where there was a mortgage registered in 1993 that had never properly been taken off title. It just forgot, right? Because years ago, what happened is if you paid off your mortgage, the bank would send you the discharge in the paper, in the mail. And they might put in the letter that you had to take it to the registry office but lots of clients, they look, oh, great, I got my mortgage paid off. They put it in a closet, right? Not knowing that there was one more step that they had to fulfill was take it to the registry office and get that document taken off title, right? So sometimes we close a transaction, especially people that have owned a house for, 20, 30, 40 years, right? They might have an old mortgage that was paid out in. This one here, got it last week, closed in 1993. Now, the other lawyer, he called me, right? We spoke right away. I said, listen, I'll try to track it down. I said, we both know it's been paid out. There's no way a mortgage that's been sitting there since 1993, right, hasn't been paid out. But the problem is you've got to actually get the paperwork. Now, this lawyer was willing. He said, Gerry, if you give me your undertaking that he could have said, sorry, I'm not closing unless you get that mortgage off.
What's that mean, your undertaking?
You say,
you're taking responsibility for it.
I promise you I'll take this off. It may not be today, and maybe in a week, and maybe in 2 weeks. And that's how most transactions close. Like if, you sell your house and you've got a mortgage on your house to CIBC, well, I'm not going to have the actual paper from CIBC to take that mortgage off. I'll have a statement from CIBC saying that, Nick Karadza owes us $150,000, right? So I send that letter, that statement to the other lawyer so that he sees that we've got something from the bank. And then I give him my undertaking that I will actually register a document that takes that mortgage off title. And sometimes I've acted for a purchaser. I'll have a client call me and say, I went to this guy. He says, there's 2 mortgages on my property. Well, yeah, there's 2 mortgages because you only closed 30 days ago. and there's still a mortgage to TD, and your new mortgage was with Bank of Nova Scotia. But I've got this lawyer's undertaking that promises that he'll take it off. And if he doesn't take it off, my recourse is to contact the Law Society, right? And that's why I have to use lawyers, because you've got the Law Society that backs up that undertaking. So if that lawyer dies, that lawyer, files for bankruptcy, that lawyer gets disbarred, right? I still have the Law Society that covers that undertaking to get that mortgage off. And that's how unless it's a private mortgage. If it's a private mortgage, you actually need the discharge on the day of closing. Because, if you close, Nick holds a mortgage on a property and I pay Nick out, right? And 2 days after we close, he hasn't signed the discharge yet, and God forbid something happens to Nick. Well, I got nobody to sign the discharge. Right? When it's the CIBCs of the world, you don't have that to worry about. But the Law Society requires, if it's a private mortgage, you must register that mortgage on the day of closing. So, if you're acting for a seller and you see that there's a private mortgage, you need to reach out to the other lawyer. You need to make sure he has a discharge ready, right? So that it all sort of happens simultaneously, right? You get the mortgage off to him, you get the check off to him. He then registers his discharge, and the purchaser's lawyer then registers his documentation. So it all happens simultaneously. With an institutional mortgage, the lawyer is entitled to take an undertaking that you'll have it removed.
I cut you off. You're thinking something?
No, go ahead.
Because one of the other things that I learned from you that made life a lot easier when it comes to agreements with anything was that to not, if you're putting in an agreement that some work needs to be done, or there's some conditions about something and someone's going to take care of something, to always put in what the penalty was or what are the consequences if they don't take care of that. And it's something that we've used time and time again now that's been so valuable, because for anyone buying a property, and there's lots of people that will buy properties private, less so maybe in today's market, although it's picking up again, it's getting kind of more active. But when there's more private sales going on and people are doing their own paperwork and looking at their stuff, you can get yourself in trouble if you don't do things right. Like, everyone should get things reviewed by a lawyer and stuff.
Absolutely.
But it was so nice when you said, hey, so look, if you're supposed to redo the roof or replace the furnace or whatever, and if you don't, here's the consequences, versus leaving it up to closing. And then it's like, well, get the agent to call this agent or get your lawyer to call your lawyer. And everyone's like, what the hell's going on? And I know it makes your life easier, but it just protects everyone.
Absolutely. And the law in there is really clear. If I buy your house, Anthony, and we agree that you're going to put in a new roof before closing. Comes the day of closing, client calls me, says, well, he didn't do the roof. Unfortunately, the purchaser must still close the transaction. He doesn't have the right to hold back money. He doesn't have the right to delay closing. He's got to close the transaction and then sue the seller for the cost of repairing that roof or replacing your new roof. And that's where instead we put, as I said to Nick and the team here, put a clause that says, hey, if it comes closing 5 days before closing, you haven't got that roof done, I get to hold back $5,000 or I get to hold back $10,000. And if you don't do it within 14 days, then you forfeit that money. And if you make the penalty substantial enough, like if the roof's going to cost $5,000, well, don't make it $4,000, make it $10,000. So now if I'm the seller, I go, wow, I'm going to lose $10,000 if I don't fix the roof, and they're going to be entitled to. There's some incentive to doing it. Otherwise, the law is really clear. You have to close a transaction. You're not entitled to delay closing. I go. I've had clients day of closing go in and go, oh my God, this is wrong, that's wrong. And I say, that doesn't give you a cause not to close. The law is really clear. Mr. Buyer, close your transaction and then take the seller to court. The problem is I take the seller to court.
That's cool, yeah.
He's moved to California.
That's very cool.
He's moved to California. How am I going to track down the seller?
See, I'm coming from the other angle, because when we were buying properties, I learned this the hard way, is, that we learned this by being told, hey, you got to close. It doesn't matter. I'm like, what do you mean? These guys didn't live up to the terms in the contract. So that's why I didn't look at it as being cool. I'm like, the guy said in the contract he was going to do this. It's not done. Why do I need to close? It didn't make any sense to me.
Yeah, if that is a part of the contract, why is it any different than the clause? Like, why is that not enforceable? They broke the contract.
It is enforceable. It is enforceable. But here's the reality.
You have to go afterwards.
Yeah, here's the reality. I mean, if you think about it logically, generally law is logical. Not everybody agrees, but generally law is logical.
Yeah, that's definitely up for debate.
But, I'm a purchaser. You said you're going to do the roof. Comes day of closing, and I go, I don't like the way you did the roof. I'm not closing. Part of the contract that I've got to be satisfied the way it's closing, right? Real estate would be a disaster.
It's too subjective.
Exactly. So the law is, Anthony, close your transaction. If you don't think he did a good job on doing the roof like he agreed to in the contract, your remedy is take him to court, go explain it to a judge. If the judge agrees with you, you'll be awarded damages. Right? You don't like the condition the guy left the house. He was supposed to have brooms swept. He's left garbage in the house, etc. Law says, close your deal, get the thing cleaned up, take your action to a judge, right? Explain to him what happened. If he agrees with you, he's going to give you a judgment against the seller. Otherwise, it would make real estate. So I got a client that kind of wants out of the deal. And he says, he left a bag of garbage in the house. I'm not closing. He didn't. Where's the limit? Where do we stop? One bag of the door handle is loose.
Yeah,
I'm not closing. It's not the way it was when I purchased it. Right. So instead of making it subjective, the onus is close and then seek your remedies. Now, if it's a problem, there's a title problem, right? The guy doesn't own the place, or there's a lien that can't be removed. Different scenario. If it's something that goes to the root of the title of the property, obviously you're not obligated to close the transaction, right? But if it's minor stuff, and honestly, a $10,000 roof repair on a $700,000 house really is a minor thing.
So where does the threshold lie then? Because if someone does, I agree with you. Like, one thing that I think can be taken for granted in Canada specifically, if you haven't bought properties in other countries, you can take for granted that how easy the process is here, and it's for those types of reasons. Like, it's very easy. The number of transactions that go to like a firm deal to close, the percentage is very high. Like, it's really nice that way. But what would it take for it to be justified that the person not close? So let's say, and I'll just give you an example. I don't know if this is true or not. So buy a house, a bunch of rain comes in the week before, and it's obviously like there's been pretty, not severe like flooding in the basement, but there's been a lot of water leakage where there's water damage across a good chunk of the basement, and the drywall's all moist and stuff like that. So there's like a decent chunk of the home. There's tens of thousands of dollars of repairs now that have to be done, right? With the total extent a little bit unknown. Is it still like, tough, you're going to have to close and then move on?
Yep.
So where does it like, what if a tree falls on the house and knocks half of it down?
So house burns down. Let's take a crazy example. The house burns down to the ground.
You're closing on the property?
Well, so in that particular case, a house burns down to the ground.
You still like this? I think you think it's cool?
What agreement clause can we put in?
Well, you as in that scenario where the house burns down to the ground, you as the purchaser have the option. You can opt out to buy the house. You can say, no thanks, I don't want anything to do with it. Because, what you bargained for is no longer there. Right? That's the reality. So that's the extent. And that's a really, subjective test. What's, substantial. But I'm using a crazy example. The house burns to the ground. Or as the buyer, I can elect to complete the transaction, right? And the seller assigns his insurance rights to me. So I negotiate with the insurance company for the rebuild of the house.
So it is really a buyer beware scenario.
No, it's very buyer beware. Very buyer beware. You have to, and that's why it's really important that you put, tight clauses into an agreement. One example, and 7 months ago, client owned a property, but there is a Planning Act problem, which lots of people still are not aware of. You know, I own House A and I own House B, and they're both beside each other. There's exemption. There's ways around it, but sometimes there's not. I own both properties. They're part lots on plans of subdivision, right? They're abutting. Guess what? I'm not selling Part A as long as I retain ownership of Part B. I've got to go to the Committee of Adjustments and ask for a severance.
Yeah, because they automatically are put together.
They merge.
Did you know that?
The title is they merge.
If you own two properties side by side, two lots, I don't know if there's some exceptions or not, but for the most part,
Yeah.
if you buy two properties, what if there's a house on each property?
Same thing.
It'll still merge. So it merges into one property. So you can't sell. So you buy your neighbor's house. You can't then just go ahead and sell your neighbor's house. You have to go and get the lot severed because it automatically becomes part of.
Why? What's the purpose of that rule?
Well,
Yeah, what is the purpose of that?
Well, ironically, when they passed the Planning Act years ago, it was passed more because, you know, I used to own a 100-acre lot. And I'd say, Anthony, here's 2 acres for you. Nick, I'm going to sell 1 acre to you. I'm going to sell half an acre there. And, you know, if you go to some of the older parts of Toronto, Hamilton, like you'll see a property that's like 100 feet wide, and you see another one that's 40 feet wide, right? Because there was no control. I mean, as the owner of the property, I could divvy it up the way I wanted. So when they passed the Planning Act, the idea was to say, no. Before you split off any piece of property, we want to know it fits in to our municipal plans. We don't want a 100-foot lot beside a 30-foot lot. And we don't want, you know, the 30-foot lot. So they wanted to be able to control it. And that's what the Planning Act was meant to prevent. Unfortunately, the Planning Act says, and I'm sort of rewording it a little bit, but the Planning Act says I must sell everything that I own. I can't retain any piece of that property. So I can't sell my backyard to you and keep the front yard, right? That's a crazy example, but, right? Just like once I own this property, if I own the one next door, again, there's exceptions to the rule of plans to sub the whole lots, you know, lots of things. But in older parts of Toronto, older parts of Hamilton, those two properties may merge, become one, and under the Planning Act, you can't retain one, you can't keep your backyard and sell your front yard. You've got to sell both pieces together. And lots of lawyers have run into that problem. I had one where son comes to the lawyer and says, hey, you know what? My parents are getting older. I'm the only child. We're going to put my parents' house into my name. So that way, you know, when they pass away, we don't have to probate, et cetera, et cetera. I'm not getting into the pros and cons of that, but in this scenario, that's what happened. Well, the lawyer never bothered to ask the guy, well, do you own any other property? Well, guess what? He owned the house next door. And the lawyer never bothered to check. Put the house in the son's name, right? Guess what? Those two properties then merged. They became one. So now, unfortunately, you got to go to Committee of Adjustments. And the problem with going to the Committee of Adjustments is not so much, generally, it's a slam dunk to get the severance, but it's going to cost you lots of money. And the properties that are there must comply with the current bylaws that are in place at the time that you're seeking the severance. So if, you know, when I built the house, the side yard requirement was 2 feet and it's now 4 feet. I now have to go to the Committee of Adjustments and ask for a minor variance to reduce that requirement from, 4 feet back to 2 feet. A lot of times the city will ask you to convey the front part of your property for street widening purposes. They'll ask you to convey that so that they can make some conditions. Usually get it, especially if there's two houses there. But that is a problem. So when we act on a purchase, right? If it's a part lot, we always check abutting properties. We check to see if the owner currently owns any abutting property or if you own any abutting property. Because if you're buying your neighbor's property, You can't buy it. So if you own property A in just your name, you can buy property B in your name and your wife's name. So as long as your name can be on both properties, but it can't be identical. So Nick buys property A.
Oh, okay.
Tom and Nick can buy property B, right? But if Nick buys those two properties, they merge on title and you've got to get a severance.
How much does a severance roughly cost?
By the time you're done, you're probably looking at 20 grand. By the time you got to pay legal fees, a planner, right? You got to bring the application. You're probably looking at 20 grand.
How's that for a surprise?
Yeah.
Damn.
Yeah.
And
that would kill us. So we were talking earlier about what would kill a deal. So if I do my search of title and I go, hey, Jack, your client owns both properties and it contravenes the Planning Act, you can't close a deal. I, as the purchaser, have the right to get out of the contract.
Okay, so let me ask you something on that, because this has come up recently just in a situation we were involved in. In that situation, who is their liability? So I'm the purchaser. I'm buying from Anthony. He was in that situation, didn't realize that the lots were merged and can't sell me the property we had agreed to. I'm like, no, I don't want it or whatever. Or I'd be willing to close and I get both of them. Actually, I score. Yeah, I score. So I guess there's got to be some liability involved there. So in those circumstances, where does the liability? Because I'm thinking I'm buying a house, I'm moving into it. I have my family, I'm moving into a house. I don't have a place to go now.
There is no liability. It's
no?
Contracts frustrated. Now, as the buyer, you can agree to extend the transaction until the person gets the Planning Act straightened out, right? So you have the right to say, well, I'm willing to wait. Take it to the Committee of Adjustments. But say you go to the Committee of Adjustment, the Committee of Adjustment says, sorry, we're not giving you the severance. Your contract's frustrated. No one's liable. That's the end of the contract.
But wouldn't it still have to go through? Like, wouldn't you be like, oh, great, I get this whole extra house?
No.
And I would be forced to sell it?
No. It's no different than, again, go back to my car analogy. I come to buy your car and, we both think you're selling me a Volkswagen. It turns out to be a Ferrari, right? we're not buying what we bargained for. I can't buy both pieces of property off you when our contract only says Part A.
I learned this was really interesting to me, and it's a big point, I think, at least, that I don't know how to word it. You would be able to word it better, but basically you're not allowed to benefit from like an error. Do you know what I mean? Like, so we had an example once where we sent, this was years ago, so we don't do this. So I've only ever done this once, just for anyone listening, just very clear. But we sent money to the wrong side of a party, right? The check went to the wrong person. So we, it was after a deal had closed, and the money went there. The check was quickly deposited. I'm sure they were happy to get the funds. And I think we reached out to you, like, Gerry, what the heck do we do? He's like, hey, you're like, I'll send a letter. They're like, it's actually there. Like, it was our mistake. And the check was made out to that person. They've done nothing fraudulent because they had a check in their name. They went and deposited it. But they were not allowed to keep that money. My understanding was they were not allowed to keep that money based on like an error on our part, because they weren't entitled to that money, even though we gave it to them. So the law actually requires that they return those funds.
Correct.
Right?
Correct. Yeah. And
so that's the same type of thing.
And remember, I mean, in Canada, we have equitable rights. We have legal rights, that statutes, cases, etc. But we have equitable rights, a sense of fairness. Like, it's not fair that because I made a mistake, you get to take advantage of it, right? It's just
that's actually really
an
good
equitable right. Well, yeah, and it's an equitable right? I mean, we made that mistake, and the courts would rectify it. So if I take you to court and I say, hey, I sent Anthony $100,000 by mistake, you can't sit there and say, too bad, so sad, right? I mean, a judge is going to go, Anthony, you got to give it back to him, right? Just like, someone that does work, and I've used this with contractors, for example. Somebody comes in and does a bunch of work on your house, and he gives you the bill, and he says, it's 50,000. You go, what do you mean? We agreed it was going to be 10 grand. No, it came out to 50 grand. Well, he can still sue you for the work that he did, even though maybe you didn't have a contract, but right? Because the law says, but Anthony, you've benefited from the work that he's done to your house. Now, maybe I'm not going to owe him 50 grand. I'm going to have to get the drywall guy in to say, well, it would have cost 5 grand to do this. I got to get the framer to come in. And so at the end of the day, I might owe the guy 20 grand. But I can't just say to the guy, too bad, buddy. You did the work in my house. We didn't have an agreement that you were going to do the work. I benefited from your work because you fixed up my house. You put in new drywall, you put in a new roof, you put in all new trim. I still have to pay for that. Right? I can't just say too bad, so sad, because we do have laws that talk about fairness in Ontario, courts of equity, which is way back in England, right? When historically you could go to the courts of the law where you'd say, hey, this is what the law says, and he didn't do this, or you could say, well, the law doesn't really say this, but it's not fair that Nick takes advantage of my mistake. And, maybe we didn't agree on the price, but the fact of the matter is I did the work. I painted the guy's house. Well, I want 20, he only wants to pay me 2, but let's see what's fair. And, we can get some quotes, and that's the way our court system works.
When does it make sense? At what value does it make sense to start really kind of trying to go after someone, like file an actual lawsuit for someone? Because there's the filing fees, which isn't much, but I guess if lawyers get involved, if you're trying to, I feel like I want to sue Anthony for $5. Not $5, sorry, $5, we're good. But for like $5,000, is it, is that something that I would just I'll take my chances. I filed the paperwork. I represent myself. You hire a paralegal.
We do lots of times. And that's a huge problem. Sometimes you sit there and you say, I wish this was 30 or 40 grand rather than $3,000. Because, as a consumer, you go, what do you mean? He ripped me off 3 grand. I want my 3 grand. And I think we talked earlier about the example about closing days. I had a client once, and I talked about this in our little interview that we had earlier. I had a client, closing day, gets to the house, nobody's packed up. The guy ends up having to put his furniture in storage. Him and his kids and his wife had to sleep in a hotel for 3 nights. But the guy didn't end up getting out of the house until Sunday night. Let's sue him. I go, okay, so what are we going to sue him for? $400 to put your furniture in storage. You spent another $500 on a hotel. You spent another $200 for food. Okay, so you're out $1,500. Is it worth the $1,500 to take him to small claims court and sue the guy? Now, the beauty of small claims court is that it is intended to be so that you can go on your own without bringing a lawyer or a paralegal. So, you know what? You're a principled guy. Go, no, what he did is wrong, and he should pay the $1,500. You can go to small claims court. You can file. You can, put your little story on a piece of paper, file it with the courts. They get the guy served with the documents, right? You go in and you have a settlement conference, and you get some judge to give you his decision. But
what's it cost to file?
I think it's $100. It's only like $100.
And up to what's the limit for small claims?
I think it's 30. I think the limit's 30 grand
30
now.
grand?
Yeah, I don't know if it's gone up to 50, but I haven't been in small claims court in 100 years. But I think it's 30 or 30, maybe even 50,000 now.
And that initial step is a settlement conference.
Yeah, the first thing that happens is once you file, the party that you're suing gets an opportunity to file a statement of defense, right? And then you both attend at what's called a settlement conference, where you sit in front of a judge and without really any evidence. You're not calling any witnesses. You're not calling anybody. You're not, you're going saying, Your Honor, this is what happened. The defendant gets an opportunity to say, no, this is what happened. And the judge would say, well, if I was the judge on this case with what you're telling me, assuming that, plaintiff, you can prove what you're saying, and defendant, assuming you can prove what you're saying, I would rule in favor of the plaintiff. or I would rule in favor of the defendant, right? And what he does in that case, he'll go, okay, Nick, you owe $1,500. Would you take $750, Mr. Defendant? Would you pay $750? 90% of the time, right, the parties end up resolving, but not always. Not always. Well, we had a case here where somebody refused to pay commission. Remember? Because it was.
Oh yeah.
We had a case here where the guy refused to pay the commission because the deal got extended 3 days, and he blamed the real estate agent.
That's right. Yeah, yeah.
Right?
That was a while ago now. I forgot.
Yeah. We end up having to go to small claims court, and even the judge said, and when we went to the settlement conference, the judge said, but the 3-day delay wasn't the real estate agent's fault. Right? It was the purchaser's fault. He wasn't happy with something, couldn't get his financing together. You as a seller, why are you refusing to pay the commission to the guy that sold your house? Right? If you feel that you've suffered some damages, your recourse is against the buyer. Right? Like if I had some extra per diem, I had some additional carrying costs, you should be suing the buyer. No, settlement conference. No, I'm not settling. We end up having to go to court. And
that's right.
I think if I remember correctly, we offered to give the guy $1,000 reduction on his commission to settle it. And he said no. So in small claims court, if you make an offer, so typically in small claims court, they'll pay a 15% of your. So if you win $10,000, the judge can award you $1,500 for your costs, right? But if you serve an offer to settle, so if you say, okay, you're suing me for $10,000, I'm willing to pay, or I'm suing you for $10,000, but I'm willing to accept $9,000 as a settlement, right? And you don't take that, and we go to court, and I'm successful in getting $9,000 or better, then you got to pay me 30% of what the.
Oh, I didn't even realize that had happened.
Yeah, you can. So in our case, we offered to settle for $1,000. Right, we offered to give the guy a $1,000 reduction on the commission. Refused to take it. Went to trial. Got 100% of our commission. Right. And we end up getting 30%.
I think he was misled. The impression I got is that he was misled by his lawyer. I think he had bad representation, if I remember correctly. And the reason I say that is I think if I remember correctly, some of the issue came with, because of his delayed closing, the amount of additional legal costs was extreme. And I'm like, why is there, like, I understand there's more work, but even you had looked at it, like, why are the legal costs, why did they jump that much? It was like thousands of dollars. And like, for a 3-day delay in closing, I have never seen that before. I didn't, closings get extended all the time, right? Like,
well, I remember, I remember my office is in Ancaster. The other lawyer was in Oakville. And, typically if there's an extension, there might be an additional $750, maybe $1,000 in legal fees for redoing the paperwork, a little bit inconvenience for the client. Right? But to your point, I think there was like $20,000 or $30,000 in additional legal fees. And I remember saying to the judge, I said, I got to tell you, if you can charge $30,000 for an extension in Oakville, I'm moving my office from Ancaster.
That's right. Oakville. That's right. You did say that. I forgot.
I said, I'm moving to Oakville because the best I could squeeze is maybe $750. Yeah. Like it was an astronomical. Like it was a number that was like mind-boggling. And even the judge said, "Come on, it was a 3-day." Oh no, but I had to do this. I did this. I did it. And he had. And anyway, to make a long story short.
I started chirping the lawyer. I remember when they left, when we were leaving the settlement conference, we were in the hallway and they were walking by us, and I started chirping the lawyer, and you were just like, Nick, shut your mouth. I'm like, I don't know, I had to say something. I couldn't not say something,
Yeah. It's out of the courtroom. It's off record.
Yeah. So, small claims court is there, and it is a dilemma, right? Like, what's that magical number? Is it $5,000 that you bring in a lawyer? Like, what we try to do, what my office tries to do is we'll typically give a client sort of a flat fee to get to the settlement conference, right? We might charge $1,500 to $2,000 and issue the statement of claim, get the party served, and attend the settlement conference, right? Because again, if it's $5,000, $6,000, you can't say to the guy, we're going to charge you $4,000, right? Well, okay, great. I'm going to court for $1,000, right? So what we try to do is, because you got to service, right? You got to offer your client that service, right? So we try and do a flat fee, get to settlement conference, try and resolve it. Like I said, 90% of the times it gets resolved, right? The judges that sit in small claims court are really, really good at getting the parties to try and resolve it, right? But once that's over, if it's got to go to trial, now you can't, it's hard to give a flat fee, because now all of a sudden, if you go into trial, you're calling some witnesses, right? Typically, you're calling a witness, right? You got to cross-examine their witnesses. You got to examine your witnesses. You got to submit some, so all of a sudden.
There's time involved.
Yeah, there's more time. Yeah. Where settlement conference is a little, it's a little simpler. Like I said, you're not calling any evidence. If it's Nick against you, we go to court. We're not calling any other witnesses, right? You give your story to the judge. You give your story to the judge, and he gives us his opinion. And that's all it is he's giving his opinion, and that solves it. But if you go to trial, I don't know what that. I mean, to me, I would say probably $10,000. I mean, it's got to be at least a $10,000 claim.
It depends the circumstances, I guess. If you feel slight, like if you're really wronged too, the hard thing is you got to take the emotional side out of it. We've probably all learned. We've all had our experiences where it's like, if you don't take the emotions out of the decisions, it can really kind of blur your vision sometimes, right?
Yeah, and with lawsuits, you burn me for $10 today, and 8 months from now, it's not $10 anymore.
Yeah.
Okay, give me $5. Right? I mean, that happened, right? I mean, that initial, as soon as it happens, I end up having to dish it. 6, 7 months, 10 months down the road, you're going, okay, it's,
I don't know if it was like $5,000 and I could outsource it to like Gerry to get it, 90% settlement rate up to that point for $2,000. Like I would probably do it for the $3,000.
Maybe. Yeah, $3,000. Yeah. Or you can do like in that type of stuff. If it's very simple and it's a smaller amount, you could really file it yourself.
Yeah.
Like it's not the most time-consuming process either if you wanted to. And the settlement conference, like you said, is really he said it's two versions of the story. And then the judge I remember with one of ours for something else, we were there, the judge looked at the person, the other person, he said, hey, is this, it was one of our early ones with a rent-to-own contract, because we're like, okay, well, let's see if this thing holds up, right? And they did, and we started telling investors, hey, man, they've passed the test, they've passed the court case, and the judge looked at it, he said to the guy, like, hey, do you speak English? Do you understand English? I was like, yes. And he wasn't trying to be smart, but he was just trying to be like, is this your signature on this agreement? He was like, yes. And then he basically said, like, I would strongly advise you, based on what I'm seeing, I would strongly advise maybe not proceeding because it might not end in your favor. Yeah. But he goes, it's up to you. Like he said, it's up to you. But he was just trying to basically tell him, like, look, like, this is all on the up and up. There's nothing fraudulent here, and then we settled.
Because the guy wasn't able to buy out the property with the rent-to-own contract.
You know what happened in this circumstance? The guy actually, he was there for years. He was a good guy. We got along with him. And then he got a girlfriend or something moved in with him. And then she's like, oh, we're going to do this, 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 and this. And his whole plans changed and everything changed. And he's like, this doesn't work anymore. You guys need to do this for me, this for me. We're like, well, hold on. We don't need to do anything. That wasn't part of the agreement. You've been here for years. Everything was okay. Now, all of a sudden, in the last few months, as she moves in, everything's a problem. We didn't say that to him, but in our heads, we're thinking that. We're like, no, that was never part of the agreement. We're living up to our end of the bargain. We've actually been very accommodating to you. We've extended it for you. We've done nothing wrong. And he felt like we had, and that was it. Then they moved out, and he wanted to sue us for the down payment and the credits back or something like that. And it didn't go anywhere. It was, we were very open and upfront. Another thing I've learned from Gerry too is often when it comes to legal thing, it's, are you acting in good faith? Yeah. If you're acting in good faith and, things like if no one's trying to take advantage of each other, it's like sometimes there's circumstances involved and it's the way it works out. I guess like you said, I never thought about it like that, but the law, I guess, often it's like, it sometimes doesn't make sense, I guess, maybe to me on an emotional level or things, but it comes off kind of fair, logical.
And the term in law is, if you go to court with clean hands, with clean hands, that usually bodes well. Right. If you can go to the judge and say, hey, I've done this, and and with the rent owns that are almost a thing of the past. I mean, there's not too many more.
I think with affordability and rates, I know
they may end up coming back.
Well, we just can't. It's so hard to find property at this point, to be honest with you.
right.
But there's definitely. I got a call today from someone that was referred to us from someone like a long time ago, and they're looking for a rent. They're like, hey, can you help us get into a property?
Well, I had one rent to own, and the tenant missed the deadline on the closing. I'm supposed to close February 1st, and we'd been negotiating with them beforehand. We again, clean hand theory, right? I mean, they need an agreement of purchase and sale in order to get their financing. We cooperated with them. We did the agreement of purchase and sale. We did everything in our power to help them purchase this property. For a number of reasons, they weren't able to close. And I think like 3 weeks later, the lawyer called me and said, hey, we're going to close. I said, well, my guy wants more money now. Well, what do you mean? I said, well, this is when the market was going crazy. I said, well, the property's gone up. Probably at that point it had gone up 200. And in fairness to my client, he didn't want the 200, but he wanted a little bit more. He thought the property's worth more. And they issued a statement of claim against my client, demanding specific performance that he comply with the terms of the option to purchase that they had tendered on us, and they brought a motion to have a certificate of pending litigation, which means they wanted to put a lien on the property so our client couldn't deal with the property. And to put a certificate of pending litigation on trial, all you have to do is convince the judge that there's a chance you're going to win. You don't have to prove to them that you're going to win. You just have to convince the judge, there's a chance that I'm going to win this. And we went, and first of all, the lawyer on the other side sent one of his juniors, because I think he thought it was really pretty straightforward, sent his junior. And I never forget, the kid goes to me, goes, well, if we settle now, we're not going to charge you for our costs. I go, I don't think you're going to win. I personally, and I had said to my client, I said, look, if we get there and the judge says that they might be successful, I said, we'll have to regroup and decide what our next steps are going to be. Anyway, we argued, and I kept saying to the judge, the contract's really clear. Closing date was supposed to be February 1st. I said, just like the stock market, I have the right to purchase a stock. February 1st comes, my option to purchase expired. If I don't exercise that option by February 1st, I can't go to the Royal Bank and go, hey, I got an option that expired February 1st, but it's February 2nd. I'm going to exercise.
The price has jumped up now.
I'm going to exercise my option. Yeah. And I said to the judge, I said, and we cooperated. It's not like we did anything that would have thwarted their efforts to close.
And that's key.
Yeah,
right?
that's key, right?
Yeah.
And unfortunately for these people, there was a variety of reasons. Anyway, we finished. The judge said, I got to go think about it. And it was a young couple. I felt bad for them. It was a young couple. Felt bad. Anyway, she was out like 3 hours. I'm thinking, holy smokes, it's a long time. And she came back and she said to them, she said, I'm doing everything in my power to let you win, but you have no grounds. Yeah. It expired. She goes, and I can't get around the fact that February 1st was the deadline, and you went to Gatto on February 21st. It was 3 weeks too late.
And you feel, like you said, you feel unfortunate.
You feel bad. And then I forget that we had to argue about costs, right? Because the winning party gets their costs paid. So I stand up and I give my the other lawyer stands up and says, well, here's our account, we're happy with this. The judge goes, no, you lost. He's not paying your costs. You're paying Gatto's costs.
Oh, they really sent a junior. Oh, wow.
He was in disbelief that he'd actually lost this. And I mean, at the end, we ended up settling it. Like I said, my client wasn't a greedy guy. It's not like he wanted full fair market value. He just wanted a little bit more than what.
And they still got a deal. They still got under market.
Yeah, right. And anyway, we ended up resolving it. The couple got that, the couple ended up getting the house. They ended up paying a little bit more. But you know what? In the market, they still did okay.
Huh. Interesting.
Cool. Gerry, the one thing I'll just say before, I don't know if unless there's something else I think we might wrap.
No, I think we can wrap. Yeah.
Yeah, I just want to thank you for years, man. Years we've been working together, and I know a lot of investors. I know Anthony. I'm pretty sure you've.
Yeah, all three of my properties.
And not just for ourselves and people here, but sometimes investors will call and we're like, oh man, we've never seen that one before, and we'll reach out for a quick question to you so we can help the investors. For other members, they may not realize that the information is ultimately coming from you when we get it and stuff. So, just thanks, man.
And I appreciate
everything.
the relationship. I appreciate I don't treat you guys as business guys. You guys are my friends. And
no, it's good. It's good. Yeah, it's good. It's nice when we can chat like this and just kind of get different things, because it makes us realize different things that we don't think about. There's always something we're learning, different clause or something like that. So, if anyone's going to listen, if someone's going to reach out to you, do we share? I guess what's your website?
My website is Gatto Law. My personal email, if you want
Gerry,
to reach out.
You're not allowed to. I'm forbidding you to hand out your personal email.
Well, my office email is ggatto. That's GGATTO at gattolaw.ca. My office phone number is 905-304-5535. Any questions? Rockstar members, you get preferential treatment. I have no problem answering questions, and that's part of building a relationship with clients. I'm not going to send you a $100 bill. That's not my style. Have a question, give me a call. I said to Anthony earlier, if you're purchasing a property and you want to have an initial meeting with me, that's included in my fees. We sit down, we do a little 30-minute chat, figure out how much money you're going to need, the process, exactly what you need to do to make sure that the thing works smoothly and it closes properly, and there's no.
And that's to figure out like closing costs,
the process, who you have to call, what you have to do, because as a purchaser, you got a few obligations. You got to get insurance, you got to call utilities, there's a few things you got to do. So review all that. That way it goes nice and smooth.
Yeah. Awesome. Yeah, we'll put all that in the show notes.
Okay.
So appreciate it, Gerry.
Thank you, guys. A pleasure.
Yeah.
Thanks, Gerry.
Awesome.
All right.
Hey, thanks for tuning in. You can find every new episode of the Your Life, Your Term show on all the major streaming platforms. So Spotify, iTunes, Google Play. And if you'd like to get free copies of some of the books that we've put together, like these right here, or some of the reports that we've put together, like these right here, you can find all of those at www.rockstarinnercircle.com. That's www.rockstarinnercircle.com. That's it for now. Until next time, your life, your terms.